Welcome to this special webcast from LexisPSL Banking and Finance. My name's Jacqueline Cook. I'm one of the solicitors in the Banking and Finance team here. I'm joined today by Professor Louise Gullifer, Professor of Commercial Law at the University of Oxford. Welcome, Professor, and thanks for joining us. I was lucky enough to attend a conference recently run by the Secure Transactions Law Reform Project, of which you're now the Executive Director. Can you tell me a little bit about the project and what the objectives are?
Well, the aim of the project is to examine the current law relating to secure transactions and to look at the need and shape of future reform. It grew out of the Law Commission project that was finished in 2005 and was set up by Professor Sir Roy Good about 5 years ago. The idea is to engage with lawyers and everyone who is using the law of secure transactions. So banks, receivables financiers, asset financiers, all those involved in lending and the provision of credit, and also all those on the receiving end, that is borrowers and those who receive credit. We're only looking at security over movables, tangible and intangible personal property. We're not looking at real property. We're not looking at security over land, not at the moment, nor are we looking at security granted by consumers, just by businesses. The object is to seek to put the law in an up-to-date and coherent form so that it's simple to use and to understand, both for domestic users and also for those from overseas. Many jurisdictions have already reformed their law, and we need to learn from them as to what a modern secured transactions law can achieve and how it can help business. We've put together a case for reform which states simply what we say is wrong with the current law and how it can be improved, and this is on our website.
Oh, that's super. So who's involved in the project at the moment?
Well, as I said, it was started by Professor Sir Roy Good, and we started with a small executive committee of academics, judges and practitioners, and a larger steering committee which included bankers and financiers as well as lawyers. The steering committee was originally chaired by Lord Bingham and is now chaired by Lord Savile of Newdigate. We also now have 4 working groups made up of academic and practicing lawyers as well as bankers and financiers and other people working in the industry.
And what stage are we at then with the project?
Well, we have various operations which are all going on at the same time. And the core work is being done by the working groups. They are examining different aspects of secure transactions law, looking at the shortcomings of the current law, looking at the benefits and shape of reform. As a starting point, they're using the consultative report number 176, which was produced by the Law Commission in 2004. But they're looking again at the proposals, they're coming up with ideas which they think will work in today's business environment and which use up-to-date technology. So we have 4 working groups, one on registration, one on priorities, one in insolvency and one on financial collateral. And the idea is that they look at the consultation paper. Some of them are sending out questionnaires and surveys to see what practitioners and those in the industry think. And then they're producing position papers which they will comment on internally and then will be posted on our website for comment and views.
Right.
Secondly, we're running a series of seminars for particular interest groups, for example, the receivables financing industry, and also on specific issues such as security over intellectual property, which we hope to do shortly. And third, we're looking at the law in other jurisdictions. Partly in order to reform our own discussions and to see how reform is working elsewhere. But we realise how important it is that practitioners are up to speed on developments overseas. And so we're hoping that our conferences, our website, our various activities can provide an information point and a focus for everyone who is interested in the reform initiatives that are going on around the world. Over the last few years, many jurisdictions have had legislative reform in this area, and many are looking very seriously at reform in the future. We had a recent conference on reform initiatives, as you mentioned, and we're producing a book based on that conference, but wider in scope, which will look at reform in common law, mixed and civil law jurisdictions. We have information on our website about reform around the world, ranging from our near neighbours, Scotland and Ireland and Jersey, to jurisdictions such as Malawi and Liberia, which have introduced PPSA type codes.
And the PPSA, the Personal Property Security Act, at the moment there's one in Australia, for example, and in Canada. Can you see English law adopting that type of approach for security?
Well, one of the problems with the current English law is that it is a combination of many statutes, regulations and cases, quite a lot of it dating from the 19th century or even earlier. So it's complex, it's difficult to understand even for English-trained lawyers, and it's pretty impenetrable for lawyers from other jurisdictions. We have, of course, various textbooks on the market which seek to set out the law, including one I co-authored, and we also have some more focused books on specific areas like mortgages or whatever. But it would be much easier for everyone, we think, if the law was set out in a codified statute. And a new statute could also improve the law. It could set out clear and sensible rules on priority. It would give an opportunity to simplify the law. For example, to have one concept of a security interest rather than the many that we already have. And would allow other interests to be brought within the registration system, such as absolute assignments of receivables, which would increase transparency and would enable financiers to gain priority protection even in non-notification financing. The Personal Property Security Acts also include other devices, asset financing devices, for example, such as finance leases and hire purchase agreements, which also increases transparency and has the benefit of putting all interests with the purpose of security onto the register. Another advantage of a codified system is that it can include security interest granted by unincorporated businesses. I mean, at present, the law in the area is governed by the Bills of Sale Act, which were passed in the 19th century. The law is restrictive, it's old-fashioned, it's in desperate need of modernisation.
That's right, and some of the PPSA systems have a notice filing arrangement for security, so you can have a priority period. Are you looking at the English law should adopt that type of approach?
Well, we are, in broad terms, looking at this, which works well in the PPSA jurisdictions and in the US under Article 9. But it's not just a priority period for registration. That is a system that, for example, I think Ireland is considering at the moment. But the notice filing system, which is the PPSA system, is a system whereby notice can be entered on a register at any time, either before or after the creation of an interest, and then priority dates from the date of that notice. So if the interest isn't actually granted, then the notice can be taken off the register by the secured party, and if the secured party won't do that, by the grantor can require them to do so. Having an online register also means that entries can be made or changed quickly and easily by the relevant parties, and it means that it would be possible to do things which weren't possible under the older systems, which were paper-based, UCC and the Canadian PPSA. One example of that is to require the online consent of a grantor of a security interest before a notice is filed. There are actually a number of benefits from a notice filing system. First of all, it would do away with the period of invisibility we have at the moment. This exists between the time when a security interest is granted and when it is registered. That interest will have priority, once it's granted, over any interest created after it. But if the second secured party, the person creating the second interest, searches the register before the first interest is registered, it won't see the first interest. But the first interest, the secured party only has 21 days in which to register. Secondly, a notice filing system protects the priority of secured creditors in the negotiation period before the interest is granted. And thirdly, one filing can cover multiple interests in the same type of collateral, so that, for example, one registration can cover a number of assignments of receivables. The thinking behind this sort of system is that of maximum publicity. Once a notice is on the register, other parties can take this into account in their dealings with the grantor and can adjust their position accordingly. Of course, the wider the scope of the register, the more you achieve this aim of transparency. It should be said, though, that in some cases a requirement of registration is not desirable. And the most obvious case in relation to security is in relation to security over financial collateral. So we have a specific working group looking at issues relating to financial collateral and how this would work within a reformed system.
Well, that makes sense, I think. English law, as you know, is fairly flexible with the 4 different devices that we've got: our charge, pledge, mortgage and lien. I'm also qualified in Scots law, where it's much more difficult to take security over intangible movables. In fact, quite often people just don't do it at all. But can you see English law moving to a system, as you mentioned, of a single security interest?
Well, having just one security interest wouldn't prevent anyone doing anything they presently do. the benefits of the flexible system could be maintained. Parties could agree anything they liked between themselves, freedom of contract. But what would change would be that the traps for the unwary, which come from having different views for different sorts of security interests, would no longer be there. So to give an example, we have slightly different rules for enforcement for different sorts of interests at the moment. Now, much of this is worked around in practice because people put express provisions in security agreements. But with a single security interest, that wouldn't be necessary, and it would be simpler to use for those who weren't quite so expert in the field.
Yes, okay. But of course, we love our fixed and floating charges under English law. So if we move to one security interest, one type of security interest, what sort of investigations would you be doing at the moment to do with priority and insolvency, for example?
Well, it is true that the uncertainty surrounding the distinction between fixed and floating charges is problematic. I think most people would agree that. And it's not just us that are looking at this, but the City of London Law Society has a working group looking at this very point. Now, our view is that you can have the same practical effect as a floating charge, but by having a single security interest with statutory provision for power to dispose of certain types of collateral, that is stock in trade and cash. And then if parties want a wider power to dispose, they can do that by including a wider power in the security agreement. That's how it works under the PPSA system. The priority rule would be the first security interest to register would win, first to file.
Okay.
So that's a similar position actually to where you have a floating charge with a negative pledge clause in it, where the negative pledge clause is registered and everyone has notice of that. There would be no problem under this system with a secured party taking a security interest over all the assets of the grantor, so the practical effect would very much like the current fixed and floating charge debenture. But it does raise the issue that you mentioned as to how the distinction between fixed and floating charges is to be replaced as a trigger for various insolvency consequences. This is something that one of our working groups is looking at the moment in some detail. What we do have are various models from other jurisdictions which have had to grapple with this, most notably New Zealand and Australia. So what they're doing is looking at the models from there and also trying to work out how that could work in English law. And in particular, liaising with the group who's looking at financial collateral about the issue of control and whether some principles could be worked out as to what is meant by control.
Because I think that would be a tricky one, actually.
Absolutely.
A lot of discussion along those lines. And at the moment, do you think there are any particular assets that are causing people difficulty when taking and enforcing security?
Well, some of these we discussed at the conference you mentioned, but I think we didn't discuss this, but I think top of the list is intellectual property. Many people say that there are the rules in relation to this are difficult and complex. We have some experts on taking security over IP involved in the project, and this is one of the subjects on which we intend to organise a seminar in the very near future.
Lovely.
In terms of other assets, licences, other than IP licences, are also a difficult area, and we would actually be very interested to hear from anyone who's had problems in this regard. And another difficult area is, of course, financial collateral, but as I said, we have a specific working group looking at this asset class.
And are there any other particular problems that you're looking at the moment in the project?
Well, one particular area is the possibility of a statutory override for clauses in sale and supply contracts banning assignment of receivables resulting from such contracts. These clauses cause uncertainty for receivables financiers, they increase the cost of that finance because of necessary workarounds, and they mean that some of the very smallest businesses who use factoring rather than invoice discounting can't get finance against those invoices. Most of the PPSA systems have such a statutory override, and so do transnational conventions on receivables financing. But I should stress that any statutory override that we're looking at would only apply to trade receivables and wouldn't cover loan contracts or other financial transactions where there is a good reason for such clauses.
Okay. Secure transactions are the bread and butter for lots of lawyers in practice. Do you think this is the right time for reform, and why would you think that? Well,
we do. It's very important for an economy that we have a modern law of secure transactions, and one that is can be easily understood and operated not only by our own business community, but from those from other jurisdictions who do business with us. As I said, many jurisdictions are looking at reforming their own law,
Yeah.
and I think we need to keep up with everybody else and enable other people to do business with us easily.
And so would you like to hear from solicitors in practice about their own experiences?
We would very much like that. One of the things that we really want to do with the project is make the debate as wide as possible and engage with anyone who has views on this or an interest in the area. So we'd like anyone who's involved in the area to share their ideas with us. We set out various ways on the website as to how to get involved and how to contact us. We would love more people to participate in the working groups. Of course, we realise that there's a time commitment involved in that. So we'd also like people to join a wider group, which we've called the Consultative Forum, which is a group we could circulate with information about what we're up to, with our ideas, with papers for comment. And we see this as an ongoing process, so the more people who can engage in our discussions, the better. If people would like to know more, the best place to go is to look at our website.
Thanks very much. Professor, thanks very much for joining us today and giving us your insight into the law of security and how that might develop. If you'd like to know more about the Secured Transactions Law Reform Project, there'll be details of the website at the end of this webcast. Also, if you'd like to know more about LexisPSL Banking and Finance, our website and blog details will also be at the end of the webcast. LexisPSL Banking and Finance will be monitoring everything coming onto the website from the Secure Transactions Law Reform Project, and it will be updated in our alerts. Thanks for joining us today.